What's up, fellow entrepreneurs? It's John Fagerholm again, and today I want to talk about certain laws that I think create litigation abuse. But first, I'm an attorney, but I'm not your attorney, so please seek out legal counsel for your specific legal needs. Okay, let's talk about it. There's a very specific law that I think incentivizes plaintiffs' attorneys to file lawsuits and continue litigating cases that have relatively low damages. So most employers don't know this, but in California, if an employer loses even one claim, they are likely responsible for all the attorney's fees on the other side. So think about that. You get all the way through trial, you lose on one claim, and besides your own attorney's fees and whatever the jury award, you're also responsible for the attorney's fees on the other side. Now, if you don't think this incentivizes attorneys to bring claims or for employers to settle cases when they haven't done anything wrong, you're living under a rock. For example, in a recent legal case, the plaintiff, Ellington Gramajo, a former pizza delivery driver, sued his employer for various labor code violations, including claims for minimum wage and overtime. Now, Mr. Gramajo worked less than a year, but his case dragged on for nearly 4 years. When it finally went to trial, the jury awarded him a little over $7,000, but his attorneys were seeking $324,000 in legal fees for themselves. The trial court denied all requests for fees and costs, stating that the plaintiff's counsel had severely over-litigated case. Now, I don't know what happened specifically in that case and why it did not settle, but based on my experience, I think the plaintiff's attorney likely was asking for much more money than the case was worth to settle and was using the threat of the potential for attorney's fees to get a much larger settlement than the case was worth. Now, of course, like I said, it's just my opinion based on my personal experience. According to the reported facts, plaintiff's attorney sent 10 sets of written discovery requests and noticed 14 depositions, yet only admitted 12 exhibits at trial. This is a lot of discovery for a wage and hour case, and that is very few exhibits for a trial. Something smells fishy, right? Luckily, this court saw the disproportionate costs and ruled against plaintiff's counsel. However, depending on the California court you're in, this is not always the case. In fact, the Court of Appeals stepped in and reversed that decision. They sent the case back to the trial court to figure out reasonable fees and costs award. For employers, this case highlights the importance of being aware of the legal landscape and the understanding how courts might handle fee and cost awards in labor disputes. This case shows that while trial courts have some discretion, there are statutory codes that mandate legal fees. Even if unfair, a small problem can create huge legal fees for the other side. All right, till next time, be productive.